Well, my learned brothers and sisters, this is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I have selected a very good topic on civil matter, that is Doctrine of Resjudicata from Civil Procedure Code 1908, CPC, Civil Procedure Code, Section 11 talks about Doctrine of Resjudicata. The principle of res judicata is founded on equity, justice, and good conscience. The foundation of plea of res judicata is laid in the pleadings. If this is not done, no party would be permitted to raise it for the first time at the stage of appeal. So pleading is very important. Now, what proof is required for res judicata? Pleading in previous suit between same parties to be filed in the court, and it should be on record. Only judgment will not help you. If you file only judgment, then it is of no use. Pleadings cannot be proved merely by recitals of allegations mentioned in the judgment. Hence, pleading is required. Question of res judicata cannot be decided on the basis of judgment. A plea of res judicata can only be founded on a valid decree. One of the tests to ascertain if a finding operates as res judicata is if the party agreed could challenge it. If he can challenge it, okay, then there is res judicata. One of the tests in deciding whether doctrine of res judicata applies to a particular case or not is to determine whether two inconsistent decrees will come into existence. It is essential that the former judgment must be directly speaking upon the matter in question in the subsequent suit, and the former judgment must be between the same parties. Year 1976 SC 1659. If the matter is not in issue, either directly or substantially, in the previous suit, it will not be res judicata in the subsequent suit. Principle of res judicata has no application in a case where there is only one suit. It is the matter issued directly and substantially, either actually or constructively, and not the subject matter that forms the test of res judicata. Where there is a change of law, decisions rendered prior to the change of law cannot be pressed into service for putting forth a plea of res judicata. Plea of res judicata is one of law, and there could be no res judicata on a question of law. Decision on pure question of law does not operate as res judicata if cause of action in former and subsequent proceedings is different. Year 1995, Andhra Pradesh 17. The principle of res judicata can be invoked not only in a separate subsequent proceedings, but they also get attracted in subsequent stage of the same proceedings. Year 1977 SC 392. The plea of res judicata is one of jurisdiction of the court. So, objection on the ground of res judicata should be disposed of as a preliminary issue, and not reserved to be tried with other issue. Because if there is res judicata, then court had no jurisdiction to conduct the trial. Year 1965, Andhra Pradesh 12. This is The most important point which I'm discussing now, the principles of Resjudicata is partially embodied in three different statutes in India, in our country, namely, number one, Section 11 of Civil Procedure Code 1908, Section 42, 43 of the Indian Evidence Act 1 of 1872. Now it is Bharati Saksha Adhiniyam 2023. In short, it is known as BSA. Section 40 Evidence Act equal to BSA Section 34. Section 41 Evidence Act is equal to BSA Section 35. Section 40 Evidence Act is equal to BSA Section 36. Section 43 Evidence Act is equal to BSA Section 37. Criminal Procedure Code 1973 Section 300. Now it is Bharatiya Nagarik Suraksha Sanhita 2023. In short, it is known as BNSS, Section 337. It deals with the person once convicted or acquitted, not to be tried for the same offense. The whole trial is conducted, and if a person is acquitted or if a person is convicted, there cannot be new trial for the same offense. None of these provisions exhausts the scope of the general principle of res judicata. Each of them is limited to its own purpose. The plea of res judicata is one which a party can waive. The doctrine of res judicata belongs to the domain of procedure. A party cannot consider to have given up a plea of res judicata where all the facts and papers necessary for ascertaining the point were before the court and the parties had admitted fact of the previous suit. Year 1971 SC 1676. Year 1936 Privy Council 258. And now again, this is all are important points, but this is the most important point. One of the most important points. If a party does not raise the plea when he ought to have done so, it will under explanation 4 to section 11 CPC be deemed to have been directly and substantially in issue and will be deemed to have been heard and finally decided against him, or the party will be taken to have waived it. Now, what section explanation 4 of CPC 11 says? I'll read out. Any matter which might and ought to have been made ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in such suit. Yeah, 1973 Punjab 9. In bracket 1986, bracket complete, 27 Gujarat LR 55. The plea of res judicata is not available where there is no contest on issue between the parties and there is no conscious adjudication of an issue. Year 2004 SC 2186. The party pleading res judicata must show from the record that the court had found in his favor on other proceedings and must produce all the relevant documents for that purpose. The party who is sought to be affected by the bar of res judicata should have notice of the point which is likely to be decided against him and should have an opportunity of putting forward his contention against such plea. Year 1936, Privy Council 258. Year 1984, Patna 316. The bar of res judicata is not created by decree, but by decision. It is not the decree which creates the estoppel, but is judgment only which can be available for a successful plea of res judicata. A party will not be prevented from raising the plea of res judicata before the Supreme Court merely because it has not been pressed in the courts below. Condition. If it was raised in the first court and evidence has let in on the point when a party was waived the plea in the lower court, may revive it in the appellate stage of the same case which the other party has appealed from the decree. AR 1932, Bombay 15, 1965, all LJ 1095. A plea of resjudicata cannot be taken by a person who was not a party to either the first suit or the second suit. 1975, text LR 829. The relief which is otherwise due to the party cannot be denied to him on technical plea of constructive resjudicata. That is, said relief could have been claimed earlier as well. In bracket 1998, bracket complete, 9 Supreme Court cases, 358. Now this is a very deep subject. Generally I have touched almost all the points, but many things are left out. I'll prepare a second video in future. And this is the end of this video. Hope you have enjoyed it. You have got some very good information from me. See you in the next video. Thanks for patient hearing. If you have not subscribed it yet, please subscribe it, like it, and share it. See you in the next video. Om Namah Bhagavate Vasudeva.